Hello and welcome to Courts Today by Live Law. Let us start with today's headlines. Centre has introduced bills in Lok Sabha today for one nation, one election. The Law Minister has agreed for examination by a joint Parliamentary committee. The Apex Court has issued notice in the bail plea of Azam Khan and his son in a stolen machine case. In the Malankara Orthodox-Jacobite Church dispute, the Supreme Court has directed status quo, and it has sought data on population and assets of both the denominations. The Supreme Court is set to hear whether graduates of 3-year LLB correspondence course can enroll as advocates or not. The Supreme Court has regularized MDS admissions and has remarked that there is a dearth of super-speciality doctors in dental science field. And the Supreme Court has granted bail to Rajasthan Jal Jeevan mission scam accused Sanjay Badaya in a money laundering case. I'm your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before moving ahead, Live Law Academy is offering a value-packed opportunity for the aspiring judges. The Judicial Service Examinations Preparation Course. This comprehensive online course is designed to help you prepare for your judiciary exams. Classes are conducted by expert faculty including retired judges. You would learn from actual case studies and other easy-to-follow study materials, and you get all of this at a very affordable fee. If you are gearing up for the judiciary exams, then this is a must-check opportunity for you. Enroll today and get 25% scholarship. You can check all details at www.livelawacademy.com, and the link is also provided in the description. In a major update, two bills aiming to achieve one nation, one election were introduced in the Lok Sabha today. These are the Constitution 129th Amendment Bill 2024 and the Union Territories Laws Amendment Bill 2024. In September, the Union Cabinet, chaired by the Prime Minister, had accepted the recommendations made by the High-Level Committee on holding simultaneous elections to the Lok Sabha, state legislative assemblies and local bodies. In March, the High-Level Committee had submitted its report. In the report, let me tell you, the committee recommended holding simultaneous elections, citing the burden on government, businesses, workers, courts, political parties, candidates, and civil society. To manage the complexities, the committee suggested two steps. Firstly, it recommended holding simultaneous elections for the Lok Sabha and the state legislative assemblies. Secondly, it proposed synchronizing the elections for municipalities and panchayats with those of the Lok Sabha and state legislative assemblies, ensuring that the former are conducted within 100 days of the latter. For this, the committee has proposed insertion of Article 82A to the Constitution to synchronize the terms of the Lok Sabha and state assemblies. All the state assemblies which are constituted in general elections held after this article is brought into effect will come to end along with the expiry of the full term of Lok Sabha. For example, if the article is given effect to in June 2024, then all the state assemblies which are formed after this notification will have a term only till 2029, that is when the term of the present Lok Sabha ends. So, if a state election is held in 2027, that assembly's term will end in 2029 along with the Lok Sabha. Opposition leaders from various political parties like All India Trinamool Congress, Shiv Sena Uddhav Balasaheb Thackeray faction, Congress, AIMIM and NCP opposed the introduction of bills, calling it an assault on the basic structure of the Constitution. Though Union Home Minister Amit Shah and Law Minister Arjun Ram Meghwal expressed agreement with the suggestions to send the bills for scrutiny to Joint Parliamentary Committee, the bills were ultimately passed with 269 ayes and 198 noes. The Supreme Court has issued notices in special leave petitions filed by Samajwadi Party leader Mohammad Azam Khan, who is the former member of Uttar Pradesh Legislative Assembly from Rampur, and his son Mohammad Abdullah Azam Khan, former member of the Legislative Assembly from Sawar constituency, challenging the order of the Allahabad High Court that refused to grant them bail in a stolen machinery case. So what exactly is the whole matter? FIRs were filed against Azam Khan, who is the Chancellor of Johor University, his son and others, accusing them of misusing government-purchased cleaning machines. The machines were allegedly bought during the previous Samajwadi Party government's rule but were secretly being used in Johor University with the involvement of the former chairman of Nagar Palika from Rampur. When the new government came into power, the machines were searched for. Acting on Azam Khan's instructions, his son along with others tried to hide the machines. They were cut into pieces and buried within the university premises. In September 2022, during the investigation, a recovery team found parts of the machine hidden in the bushes on the campus. University staff, including a security guard and an employee, were present at the recovery. A case was filed accusing Azam Khan, his son, and others of criminal conspiracy, hiding evidence, and causing damage to public property under various sections of the IPC and the Public Property Act. Previously, the High Court rejected their bail pleas, citing their long criminal histories and past convictions. The court feared that releasing them could impact the trial, as key witnesses are university staff who could be pressurized or evidence could be tampered with. Well, today a bench of Justices M.M. Sundaresh and Arvind Kumar of the Supreme Court has issued notice to the state government on their SLP. Stay tuned. In the next update, the top court today heard the Malankara Orthodox-Jacobite Church dispute. This dispute between the Jacobite Syrian Church and the Malankara Orthodox Syrian Church is about who has the right to control and manage certain churches in Kerala. This conflict goes back over a century and is mainly about differences in religious practices, leadership, and interpretation of church laws. Both factions were once part of the same church, but split due to disagreements over authority. The Supreme Court ruled in 2017 that the Malankara Orthodox Syrian Church, governed by the 1934 Constitution, has the legal right to control these churches. However, the Jacobite faction has resisted handing over, leading to legal battles. The Supreme Court's judgment from 2017 had conclusively resolved the issue, and only its implementation is what now remains. Earlier this month, the Supreme Court had directed the Jacobite Church to hand over control of the churches. Today, Senior Advocate Chandroday Singh for Malankara Orthodox Church submitted that the Jacobite Church members had not complied with the court's direction. Senior Advocate Sham Devan, on the other side, appearing for the Jacobite Church members, brought the attention of the court to an affidavit filed by the Supreme Head of the Malankara Church, which expressed difficulties in complying with the court's direction to allow Jacobite members to use the cemeteries. To this, Malankara side firmly said that rituals of the Jacobite sect cannot take place within Malankara Church premises. They explained that so long as the services are performed elsewhere, burial can be permitted in the cemeteries. They also added that the state government passed a law in the year 2020 regarding burial grounds to support the Jacobite sect, and argued that the law violated the 2017 verdict. After a long hearing, the Supreme Court bench of Justices Suryakant and Ujjal Bhuyan today adjourned the hearing and directed that status quo should be maintained with respect to the management and the administration of the churches as they exist today, till the next date of the hearing. The matter has been posted for detailed hearing now on 29th and 30th January 2025. The bench also has asked the state of Kerala to furnish data regarding population of both Orthodox and Jacobite denominations, the list of churches under the complete administrative control of the both sections, the list of churches where the management is under dispute, and their current status of administrative control. And now let me tell you, the top court is set to consider a question whether a law graduate of a 3-year LLB course can enroll with the State Bar Council if the person obtained an undergraduate degree through correspondence. The bench of Justices Vikram Nath and P.B. Varale was hearing a challenge to the order of the Telangana High Court, which refused to allow bar enrollment of a law graduate with a correspondence degree in BA. The High Court had dismissed her petition as per another decision of the High Court in M. Naveen Kumar versus the state of Telangana. In this M. Naveen case, the High Court was dealing with a challenge to non-approval of the admission to a 3-year LLB course, as the petitioner in that case did not undergo a regular undergraduate course. The High Court said that the petitioner was not in compliance with the eligibility criteria set out by the Bar Council of India Rules on Legal Education of 2008, as amended in 2017, which requires an undergraduate degree through regular courses. The Supreme Court has now issued notice in the matter. Stay tuned to know further updates. The Supreme Court has directed issuance of pending degrees to graduates of Master of Dental Surgery. This is for the batch of 2016-2019 in the dental colleges of Madhya Pradesh, as their admissions taken in 2016 had been cancelled. The bench of Justice B.R. Gawai and Justice K.V. Vishwanathan was hearing an appeal filed by the graduates against the order of the Madhya Pradesh High Court, which had cancelled their admissions. The dispute here began when the regulatory authority cancelled the MDS admissions of students who had completed their BDS degrees from Karnataka, Gujarat and Maharashtra. The cancellation was based on the ground that these students had not participated in the counselling process, violating a 2016 Supreme Court order. This decision was upheld by the appellate authority. The affected students filed a writ petition in the Madhya Pradesh High Court, which initially granted an interim stay on the cancellation. However, after the students completed their MDS courses, the High Court's division bench dismissed the petition and upheld the cancellations. The students then approached the Supreme Court to challenge this decision. The state of Madhya Pradesh and the Dental College of India argued that the admissions were not valid as they were backdoor entrants and they had not undergone the counselling process. But the Supreme Court rejected the contention and observed that MDS admissions of other students who completed their BDS from Madhya Pradesh and the same college and were similarly situated had not been cancelled. The bench also remarked that there is a dearth of super-speciality doctors in the field of dentistry. The court held that if the appellants are not regularized, their time spent on clearing the degree would go to waste, and so it has set aside the High Court's order as well as cancellation orders. But the court also clarified that this order is only as per the peculiar facts and circumstances and cannot be treated as a precedent in any other matter. And lastly, the Supreme Court has today granted bail to Sanjay Badaya in a money laundering case arising out of Rajasthan's Jal Jeevan mission scam. Badaya was arrested by ED in July this year and he spent nearly 5 months in custody. According to statements given by co-accused, Badaya facilitated payments of bribes and managed the PhD employees on behalf of the then Minister Mahesh Joshi. After the Rajasthan High Court denied him bail in November, Badaya approached the Supreme Court. A bench of Justices B.R. Gavai and K.V. Vishwanathan has granted him bail, taking into account the fact that co-accused Piyush Jain has already been granted bail. That trial is not likely to be concluded in the near future, and also that charges are yet to be framed. The court noted that the co-accused Piyush Jain also had similar allegations. While Piyush Jain was added as an accused in the predicate offence with proceeds amounting to 8.87 crores, Badaya is accused of receiving 3.3 crores with 1.5 crore deposited in his father's account. The court observed that charges are yet to be framed and the evidence spans 8,000 pages with 50 witnesses. So it concluded that the trial's early conclusion was unlikely. Thank you for watching. For more information on the cases that I discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.